Welcome to In the Courtroom and the Boardroom, Business Law and Litigation with Colleen McKnight.
Welcome back to In the Courtroom and the Boardroom with Ms. Colleen McKnight. Colleen is a seasoned trial attorney and the founder of McKnight Law, where she helps business leaders protect what they're building through litigation when necessary and legal strategy whenever possible. I'm Evan Mack, and today we're talking about temporary relief. This is temporary relief with our TROs, TIs, and PIs. Ms. Colleen, how are you?
I'm so well, Evan. It's so great to have you here.
Great to see you. Great to see you. Can we start with the basics for the people that are watching? What is a TRO and what is a TI? And a whole bunch of letters that I'm throwing at you, but can you explain it to people?
Yes, absolutely. So sometimes you need emergency temporary relief or something very, very bad is going to happen. So the classic example I always give my clients for a TRO or a TI is I want you to imagine that you have 100-year-old oak on your property line, and you and your neighbor are in a dispute about who actually owns the property that tree sits on. And your neighbor says, I'm cutting it down so that I can put in a pool, right? And if that tree gets cut down, no amount of money is going to give you back a 100-year-old oak tree,
True.
Right? You can't fix it later. Once that tree is gone, it's gone. And so the law gives you this ability to run to the courthouse and say, Judge, I don't have time to prove it, but you have to stop them. And so the judge will give you what is called a temporary restraining order, or a TRO. These are extraordinary relief because you haven't proved your claims. And so there is a due process issue with, hey, can the judge stop me from cutting down a tree that I say is on my property so that I can do what I want when the other side hasn't proved that it's on their property? And so there's guardrails that are in place for that say, look, this can only be for a very brief period of time, like 2 weeks. And then we have to have an evidentiary hearing so that you can come in and prove your claims at least enough that I feel comfortable keeping them from cutting down that tree until we get to trial. And that evidentiary hearing is called a temporary injunction. These are extraordinary relief. So this isn't something that the courts throw about and grant willy-nilly, but they can be really powerful tools to protect your business if you really are in an emergency situation.
But Ms. Colleen, what's the fundamental difference between a TRO and a temporary injunction? And how does that distinction matter in practice?
Yeah. So that, like I said, that TRO is very brief. We're talking 10 days, 14 days. It will automatically expire if you haven't taken the steps you need to get to the TI hearing. Sometimes in a case where, let's say, I think that my employee has walked out with trade secrets, I'm asking the court restrain them from accessing these documents, from using these documents, maybe even restrain them from working for my competitor until I can prove that doing so would mean real harm to my business, right? The court is going to give you a very short leash where you get a little bit of time to get your evidence together and come before the court. The TI hearing, or sometimes in federal court, it'll be called a preliminary injunction, or PI, because we just have to make it complicated, Evan, right? With this federalist system, everybody has to be different.
We do.
Yeah, that is a mini trial. So you are coming before the court and you have to prove usually 4 different things. You have to prove the likelihood of success on the merits. So Judge, I'm not going to win today, but I'm going to show you that I am likely to win when we get down the road into trial. That's the heaviest one that you have to prove. The second one is there is irreparable and immediate harm that is going to happen if you don't hold off, right? Money is not going to fix this. The damage to my business, to my reputation, to my oak tree, money's not going to fix it in the end. So I can't be made whole 2 years from now when a jury decides in my favor. There has to be a balancing of equities, right? If I have the stronger equity, but you also have claims, and sometimes we'll see this in, let's say, a drug issue, right? I've come out with a new drug. I'm saying I still have rights to it. They're producing the drug and they're saying, Judge, there's a huge shortage of this life-saving drug. And if you don't let us keep producing this, people will die, right? Maybe their business will be harmed, but if you don't let me keep producing it, lives will literally be on the line.
Oh.
So the court has to balance those equities. And then there's a public policy argument that sometimes goes into something like that drug example as well of how does this affect the public? Is it better for society if I protect your rights, or is it better for society if I let them cut down the oak tree? Those aren't always going to be equal factors that the courts are going to weigh, but that's what they're going to be looking at that temporary injunction hearing. And you have to bring evidence and prove those 4 factors to say, Judge, please hold off. Keep the status quo until we get to trial, or I can't fix the harm that's going to happen.
Ms. Colleen, when a client calls in crisis, what key facts or documents do you gather in the first 30 minutes, maybe to assess this TRO eligibility?
Yeah, so it has to be immediate and irreparable harm. And so if the client says, look, this has been going on for 6 months and I've just reached my breaking point, we're going to have a really hard time going to get a TRO and telling the judge this was an emergency. This harm is immediate because it's been going on, right? And no one wants to dive into litigation before they've really looked at, all their options. And so sometimes you might want to just wait it out. But if it really is a situation where you're thinking, this is my direct competitor, they're falsely advertising against me and they're destroying my market share. Or this employee walked out with a trade secret, and if they go and make it public, I can never unmake it public, and I'm going to be irreparably harmed. In those instances, I can say and evaluate with the client, is this immediate and irreparable? And is it something that we're likely to succeed on ultimately? We don't have to get all of our ducks in a row for the TRO, thank goodness, because there's not usually time. I mean, when I say it's emergency, usually we go the same day to the judge who's assigned to that, right? And we say, help us. And sometimes I've had some pro bono cases where 2 years ago, where it was a Jewish synagogue who the city had shut their lights off right before Hanukkah. And we were saying, Judge, we need you to stop them from doing this. You're infringing their religious liberties. Like, we're talking about constitutional rights right now. And they need to get these lights back on. And then we will figure out down the road what the merits of your complaint about this is, right? And so sometimes you have to get there very quickly to say, we can't fix the fact later. Money's not going to fix the fact that this religious community lost their religious liberties on the eve of a major, religious festival. Damages aren't going to make that whole.
Did they turn the lights back on?
They did turn the lights back on. They did turn the lights back on. The judge did not grant the TRO in that instance. What she did was she kind of looked at them and looked at us and said, I think if you take yourselves back to the room, you can come to an agreement. And often you can, in that instance, get some help. And, we had the Constitution on our side. And we were able to work it out in that instance. But I've also gone down, Evan, to try and get a TRO in situations, and the judge tells me, I just don't think it's emergent. Like, I don't think this is emergency enough. Or, counsel, I just don't see how damages later aren't going to fix this. You haven't convinced me. And so it's not granted as a matter of course. It really is extraordinary. And you are talking about stepping over somebody's due process rights. And so it's important that the courts don't just grant these as a matter of course. But for protecting your business, if there is something that comes up where you say, hey, Colleen, our head of payroll just walked out with everybody's W-2s, then I run to the court. And I say, Judge, you need to put a TRO on this person so that they don't go out and hurt every employee by stealing their identity or selling it. Right. And in that instance, the judge says, absolutely, let's do this. And then they set the TI hearing.
So how do courts weigh these four classic injunction factors, likelihood of success, irreparable harm, balance of equities, and public interest? How do they work that out?
I find that public interest doesn't come into play that often. I have
Okay.
seen it, like I said, in drug cases. And sometimes when you're talking about, these nationwide injunctions that just came up with the Trump administration saying, we're birthright citizenship and we're going to, and a judge says, I'm enjoining the whole country, right? And so you will see in those instances where the court is saying, okay, well, public policy comes into play here and the public interest needs to be held off. But in a business dispute, which is mostly what I handle, it's pretty rare that we're really going to see that factor play a huge role. I think that for when I look at it and I look at my experience and the case law I've reviewed, that likelihood of success on the merits and the immediate and irreparable harm are often the two heaviest that the court is going to look at. If you can't prove immediate and irreparable harm, you're not going to get that injunction because the court doesn't want to withhold one party's rights until trial unless they have a really good reason to do that. And then if you can't prove that at the end of the day, you're more likely than not to succeed, then the court is holding this person's rights and is likely to later have to reverse course. And so those are the things that I see the courts weigh. The case law doesn't say that the courts need to weigh them in any particular order or that they have equal weight. These are just all factors that the court is going to consider.
What strategic consideration guide, whether you file ex parte or for a TRO or notice the opposing party and seek TI instead?
Yeah. So oftentimes when you run down to court and you say, I need a TRO, one of the first questions the judge is going to ask is, have you notified the other party? Right? Are they on notice that you're here in front of me? Because that's another one of those foundational fairness questions that judges don't want to be on the wrong side of. And sometimes I've had a chance to call the other side, like in the case of Hanukkah, right? And they were there arguing with me. And I wanted them there participating in the process because what I wanted was resolution for my clients. And sometimes you don't, with an employee, you don't know if they have representation yet. You're not sure they're checking their emails. You've sent them notice that you're heading to court, but they may or may not have any ability to get there same day. And so you want to just go ahead and get that legal protection. But if you have the chance to give notice to the other side, in my experience, it's usually best to tell the court, I tried really hard. Here's the 4 times I called. Here's the 3 emails I sent. I sent these text messages. I sent them a private message on social media. Judge, I tried in good faith to get them here to participate. I just wasn't able to, right? And you're going to have to get them served. And the judge is going to want to see them at the TI hearing. And oftentimes what you're going to be looking for in the interim is expedited discovery. So the discovery process usually takes months and months, but this TI hearing is an evidentiary hearing. And so you're going to need some facts, often from the other side, to prove your success, your likelihood of success on the merits. And so, you'll say, Judge, here's the 5 requests I really need them to fulfill. And I need 1 deposition of their corporate representative so that I can prove these claims to you. And if you can't get the other side to engage, then you kind of hit a stone wall there and your TRO can expire, which is not what you want.
So, Ms. Colleen, where do practitioners most often stumble? Service issues, bonding requirements. How can they avoid these pitfalls?
Yeah, absolutely. So service is pretty important. If you can't get the other party served with the TRO, then they're not on notice and there is a fundamental fairness issue that's going to fall apart for you. And so making sure that you have all of those ducks lined up as you run to court to say, once I get this order that's going to give me 10 or 14 days of relief, I've got to get it to this person or they're not going to follow it. They're not on notice that they have to follow it and it's empty relief at that point. And so you want to make sure that you're setting yourself up for notice and getting all of the information that you can. And if you need alternative service, right? I've had lots of defendants avoid service, right? They just won't meet the process server. They won't accept the certified mail. And so you want to make those attempts as quick as you can so that you can go back to the court and say, hey, this person's really active on Twitter. Let me serve them on Twitter. Or I think it's fair for me to just tape this to their door. I know they're there. They're just not answering. So judge, let me serve them differently and count that so that we can move forward and they can be held accountable for what this order says they can't do. A bond is also an interesting part of the TRO and the TI. And so the judge will say, if I'm wrong, and if ultimately we get to the TI hearing and I can't give you a TI even though I gave you a TRO, and if we give you the TI and ultimately we get to trial and the jury says you're wrong, how are you going to make the other party whole for the pieces of this that I kept them from doing in the meantime? Right? So let's say it's a false advertising case and the judge grants the TI and he says, party defendant, you cannot advertise your product in A, B, C way. And then you get down the road, you get to trial, and the jury says, oh, no, they can. They can. That bond is in place, paid for by the plaintiff, to try and make whole the defendant for their inability to advertise in A, B, and C way during that interim. Wow. And sometimes it can be really large. If the other party comes forward and says, judge, this is going to hurt us economically in this huge way, then that bond might be $1 million. It might be $2 million, right? And so if the plaintiff isn't prepared to go get a surety or to put up that money, then they get the TI, but they can't fulfill the bond requirements. And now it's like you didn't get it at all and you've wasted all of this time. And so understanding and being able to argue, here's why it wouldn't hurt them that much. Here's why the bond should be much smaller. This person doesn't have any rights to these people's W-2s, so it won't hurt them at all not to go sell them on the market. Judge, give them a $50 bond. And then down the road, when you prevail, that bond is returned to you. And if you don't prevail, then it gets paid to the other party. But it's an important consideration for parties that are asking for this temporary relief, because you don't want to put all the energy and time and money into getting an order, which is extraordinary and hard to do, and then not be able to fulfill the financial requirements to keep it.
So, Colleen, what proactive steps can businesses take to position themselves for or maybe defend against these emergency injunctive relief before a dispute ever arises?
Yeah, so we've talked a lot on the podcast about protecting your trade secrets, making sure that you've got ironclad contracts, really setting yourself up for success in your business. And those steps are really similar to the steps that are going to protect you for the TRO. I mean, it's very hard for me to tell a business owner, you need to keep money in place for a potential bond in case this thing comes up, right? That's not how businesses are run, understandably. But if you have audited financials, it's going to be easier to go get a surety loan. If you have your ducks in a row business-wise, then we will be better off and better able to say, here's why we win, here's why there's irreparable harm. But the truth is that sometimes emergency relief isn't something you can anticipate. And so my number one recommendation is have a lawyer who knows you and knows your business, who you can get on the phone quickly when you need that help.
Awesome. Thank you, Ms. Colleen.
Thank you so much.
And thank you all for tuning in to In the Courtroom and the Boardroom with Ms. Colleen McKnight. If your business is facing an emergency order or in need of one, visit mcknightlaw.us to connect with Colleen. And don't forget to like, subscribe, and leave a review if you found this information helpful. Thank you so much for joining us.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.